Hey everyone, and welcome to This Explainer. Today we are diving into a genuinely fascinating, start-to-finish story about the complex legal framework of Philippine land registration. We're going to be looking really closely at the core principles governing land titles and deeds, which are primarily anchored in Presidential Decree No. 1529. Now, whether you're an investor, a property owner, or honestly just a focused learner trying to map out how property rights actually work from the ground up, you are absolutely in the right place. I want you to just stop and think about this for a second. Are you absolutely sure you own your land? It's a pretty provocative question, isn't it? I mean, we hear about property nightmares literally all the time. Competing claims, fake titles, or that sudden, horrifying discovery that a supposedly private lot is actually government property. We buy land thinking a simple piece of paper guarantees total security. But the legal reality of how that piece of paper actually gets its power, well, it's a pretty intricate journey. Okay, let's dive into this. Here is our roadmap through the life cycle of a land title. We'll be hitting 5 key areas. First, the Regalian Doctrine. Second, who can actually own land. Third, the Torrens System Shield. Fourth, navigating property dealings. And finally, reconstituting lost titles. Section 1. The Regalian Doctrine. The origin of all land. Okay, so to really understand private ownership, we first have to accept a fact that sounds, well, kind of contradictory at first. All land fundamentally starts with the state. This is called the Regalian Doctrine, and it is the absolute bedrock of Philippine property law. It essentially dictates that all lands of the public domain inherently belong to the state. And why is that? It's for the conservation and utilization of national wealth and natural resources. Think of the state as the ultimate original owner. Basically, before a private citizen can claim a piece of the pie, the government has to explicitly say, hey, this pie is now available for eating. And this brilliantly illustrates the two totally different buckets land can fall into. On one side, we have the inalienable public domain. Think of public forests, forest reserves, submerged areas, and seaports. These are entirely outside the commerce of man. No way around it. They cannot be privately appropriated or registered. But on the other side, we have disposable agricultural lands. These are the specific lands the government has affirmatively declassified and legally released for private ownership. But here is an absolutely critical detail that trips people up all the time. Only the executive department, acting through the office of the president, has the actual power to classify these lands. The courts, they can't do it. Plus, a forested area doesn't somehow lose its legal status just because it was illegally logged or entirely stripped of trees. A bald mountain might look exactly like disposable agricultural land, but if it's legally classified as a public forest, guess what? It remains a public forest. Physical appearance just doesn't change legal reality. Moving on to Section 2, who can own land, nationality, and exceptions. Right, so now that we know where land comes from, let's talk about who can actually hold the title to it. And spoiler alert, the rules are incredibly strict. First off, there is a strict constitutional ban on foreign ownership. Ever since the effectivity of the Philippine Constitution, an alien has absolutely no right to acquire public or private agricultural, commercial, or residential lands. None. And this absolutely applies to foreign corporations too. They can't even be a temporary transferee of land. The really only major exception to this outright ban? Acquiring land through hereditary succession. Basically, simply inheriting it. Oh, and if a transfer is illegally made to an alien, it can only be validated if that property is later sold back to a fully qualified Filipino citizen. However, property law almost always has its fascinating workarounds, right? Let's talk about the 60-40 split under the Condominium Act. This specific framework actually allows for legal foreign investment in real estate. How do they do it? Well, by separating the ownership of the land itself from the ownership of the building unit. The land is entirely owned by a condominium corporation. Foreign nationals are then allowed to buy individual units and hold shares in that corporation, up to a maximum of 40% of its total outstanding capital stock. That leaves the required 60% firmly Filipino-owned. Pretty clever, right? Now, for Filipinos who are trying to confirm an imperfect title, which just means a claim to public land that hasn't been officially registered quite yet, the timeline under Republic Act number 1157-3 is rigorous. The land must absolutely first be declared alienable and disposable by the government. Then, the applicant has to prove open, continuous, exclusive, and notorious possession since a very specific date, June 12, 1945, or since time immemorial. You can't just go squat on a public forest for 30 years and suddenly claim you own it. Public domain lands are simply insusceptible to prescription until they are formally converted into patrimonial property. Section 3, the Torrens System Shield, protecting your title. Okay, so once you successfully navigate all those hurdles of ownership, you enter the protection phase. But listen, we really need to clear up a massive misconception right out of the gate. The Torrens system merely confirms ownership and does not create it. So what does that actually mean for us? It means a Torrens title is the ultimate proof of your rights, for sure, but it isn't magic. If land of the public domain, say a public beach or a protected forest reserve, is mistakenly or erroneously included in a Torrens title, that land doesn't magically transform into private property. No way. It strictly remains property of public dominion. So the crucial point is this. Assuming the land is validly alienable, a decree of registration under the Torrens system is incredibly powerful. It acts as an absolute bar against any and all claims or rights that might have existed prior to its issuance. It permanently quiets the title. This is what we call a proceeding in rem, meaning it is directed against the whole world. Once you secure that original certificate of title, it simply overrules any competing array of older, lesser proofs. You hold the ultimate trump card. And as a really cool bonus to back up this powerful shield, the state actually maintains an assurance fund. It's basically a financial safety net specifically designed to compensate innocent folks who might unjustly lose their land or suffer damages due to errors or omissions in the registration process, provided, of course, there wasn't any negligence on their end. Section 4. Navigating property dealings. Registered versus unregistered. All right, so you've got the land, but what happens when it's time to actually buy or sell? Well, there is a drastic difference in risk here. If you buy registered Torrens land, you're generally fully protected as an innocent purchaser for value. That's someone who buys property in good faith, pays a fair price, and genuinely has no notice of any legal flaws or competing claims on the title. Because the title binds the world, you can generally rely entirely on its face. But if you are dealing with unregistered land, let me give you a very, very strong warning. You purchase that strictly at your own peril. If the seller didn't actually own the whole property, or maybe they lacked authority from their co-heirs to sell it, your claim of being a buyer in good faith will simply not save you. A transaction involving unregistered land literally does not prejudice third persons unless it's properly recorded. Section 5. Reconstituting lost titles under RA No. 26 procedures. So, what happens when physical catastrophe strikes? A fire, a flood, maybe an earthquake, and your physical certificate of title is destroyed. The good news is you don't lose the land. The bad news is you must follow the intensely rigorous rescue procedures of Republic Act No. 26. Now, what's really interesting about this is the strict, uncompromising order of preference you have to follow to rescue a title. You literally cannot just bring in any old piece of paper. The law demands a rigid hierarchy. First, you absolutely must use the owner's duplicate if it somehow survived. If not, the co-owner's duplicate. If those are both gone, a certified copy previously issued by the Register of Deeds. Only if all of those top-tier documents fail do you move down the ladder to authenticated decrees, registered encumbrances, or finally, other documents deemed sufficient by a court. You have to follow this ladder rung by rung. And the entire process splits based exactly on where you land on that hierarchy. If you have those golden top-tier documents like the owner's or co-owner's duplicate, you can file an extrajudicial administrative petition straight with the Register of Deeds. It's way faster. But if you are forced to rely on those lesser secondary sources, you have to file a full judicial petition in court. And let me tell you, this judicial route requires extremely strict notice, including mandated publication in the official gazette twice and physically posting notices on municipal buildings for 30 days. 2. That brings us to this massive singular number. When a title is reconstituted extrajudicially, or even through certain judicial means, the law actually places a 2-year statutory reservation encumbrance right on the front of the new title. What does that mean? It means the reconstitution is completely without prejudice to any third party whose valid interests might have been accidentally omitted or forgotten when the title was rebuilt. But don't panic, this restriction isn't a permanent tattoo. After exactly 2 years from the date of reconstitution, assuming no third party has come out of the woodwork with a legitimate claim, the registered owner can just file an ex parte motion. That's simply a request made to the court without needing the other parties present. The judge will then order the Register of Deeds to cancel that reservation encumbrance altogether, fully scrubbing the title clean and flawlessly restoring its unblemished Torrens shield. Now, before we wrap up today, I really want to highlight this fascinating legal failsafe from Section 18 of RA 26. If the lost original is subsequently found, the recovered original title shall prevail over the reconstituted certificate. Imagine that scenario for a second. If the original registry document you were absolutely sure burned down is suddenly found 5 years later sitting in some mislabeled box, that true original will always defeat its legally resurrected clone. The Register of Deeds will carefully transfer any valid new liens over to the recovered title and then completely cancel the reconstituted one. The original always wins. Well, we've covered a lot today. The absolute origins of land in the Regalian Doctrine, the strict constitutional rules of ownership, the sheer power of the Torn Shield and the Assurance Fund, the massive perils of unregistered dealings, and exactly how to bring a destroyed title back to life. So I'm going to leave you with this final provocative thought. Think about the property you own right now, or maybe the property you're dreaming of buying. Is your land genuinely protected by the ultimate shield of the Torn system, or are you sitting on a mountain of unregistered risk? Understanding these rules isn't just legal trivia, folks. It is the absolute foundation of your property security. Thanks so much for joining me for this explainer, and as always, keep learning.